What makes you think your case is ready for settlement negotiations? You want to know what this is all about? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Most injured patients think that from the moment when they start their lawsuit, that their case is ready to begin settlement negotiations. Most injured patients think that they have the best case in the world, that no matter what happens during the course of the lawsuit, they are going to be successful. Why? Because they know in their heart of hearts, and based upon our experts' review, that we have a good, valid, and meritorious case. But is that really the best time to begin negotiating? At the very beginning, either before you start your case or immediately afterwards? The answer, most likely, is no, it's not. You want to know why? I'll tell you why. At the very beginning of your case, unless it is so clear-cut that the doctors were so careless, and now that your injuries are so clear-cut that no one could ever dispute the extent of your injuries, in that instance, it might be a great idea to start having settlement discussions before we actually start your lawsuit. Now, some people think, just like in a car accident case, that they could go ahead and threaten a lawsuit and shortly afterwards they'll get a settlement offer. Well, in medical malpractice cases, at least in New York, it does not happen that way. The defense, the insurance companies who represent the various doctors in these medical malpractice cases, they would rather spend hundreds and hundreds of thousands of dollars defending the doctor than pay out what they consider to be a nuisance value to try and get rid of your case early on. They take the moral high ground along with the doctor and they say, listen, our goal is to defend this doctor to the very end. And if that means going ahead and spending $300,000 to do that, we'll do that. We don't care if the injured patient wants only a fraction of that, or if they want $100,000 or $200,000 or $300,000. We don't care. We would rather spend as much money as possible to defend this case to get a good outcome for the doctor, rather than offer a dime to the injured patient and their attorney. That's the mentality that we deal with on a day-to-day basis. So don't think for a second that this is anything like a car accident case where you can try and compel the insurance company to offer up a quick settlement instead of going ahead and filing a lawsuit. That simply does not happen. So now, what does happen, and why would it not be a great idea to negotiate before your lawsuit is started or even immediately after? So let's break that up. It would not be a great idea to go ahead and negotiate your case if there are issues of fact in your case, if there are disputed elements about the extent of your injuries, or if it was truly unknown whether or not your injuries were permanent, whether they are totally disabling or not. Now, why is that? It's because we likely will not know the full extent of your injuries at the very beginning of your case. Oftentimes, the doctor will say, listen, we need sufficient amount of time to determine for sure whether or not your injuries are permanent. Let's say this case involves improperly performed spinal surgery, and now you suffer severe neurological injuries, and you might be paralyzed, or you might have paraplegia. In that instance, your treating doctors may say, listen, we think that some of that function will return, but we need to wait at least a year or so in order to see if that function returns. In that instance, we don't know the full extent of your injuries. You may need additional surgery in order to address the problems that you experienced as a result of the doctor's carelessness. So at the very beginning of your case, we may not have a definitive answer as to whether or not you will require additional surgeries to fix the problem, to repair and correct the problems that were caused by this careless physician. In that instance, it would be improper on our part to go ahead and start negotiating. Why? Because the value of your injuries might be significantly higher once we know the full extent of your injuries. Trying to negotiate a case at the very beginning is often not advisable unless it is so absolutely clear-cut on the issues of liability, on the issue of causation, on the issue of damages, that yes, then in that instance, we could go ahead and start negotiating. But now, after starting your case, is it a good idea to start negotiating? In my opinion, the answer is no, it's not. If you've been watching any of my videos, you will likely know that in order to get to that point where we have started a lawsuit on your behalf, we have had to do a very detailed, thorough investigation, which included obtaining all of your medical records and then having various experts review them to confirm that you have a valid and meritorious case. That has taken us a considerable amount of time. It could take 6 months, it could take over a year, it could take a year and a half, or even more sometimes. During that period of time, we are gathering all your medical records. So think about all the time it took us to get all those records and all the time it took us to have them reviewed by medical experts. Once we start your lawsuit, the defense is now at a disadvantage because they don't know exactly what's involved. They don't know what our claims are immediately. They don't know the full extent of your injuries. And importantly, they have not yet had an opportunity to review any of your records. So one of the key functions of the defense at the very beginning when we start your case is, they say to us, Mr. Oginski, please provide us with copies of the medical records you have already obtained. Please give us permission slips, what we call authorizations, that will allow us to get your client's medical records directly from the various doctors and hospitals where they were treated. And this way we can analyze for ourselves what has gone on here. And then that will take many months for them to achieve and to obtain all of your records. And then the defense will likely do what we did, which is send all those records out to various medical experts to get opinions about what was done just based upon those medical records. And because the defense does not yet have all of this information that we already have, that would be severely disadvantageous for them to start negotiating because they don't know what we are claiming in your case. We have not yet provided them with a detailed, itemized list of the various allegations of negligence, of wrongdoing in this particular case. They don't know exactly what permanent injuries we are claiming you suffered as a result of the carelessness by their doctors. And because of that, the defense would not be willing to negotiate. Now, here's something interesting. That does not mean the defense will not try and probe and find out what we are looking for to try and settle your case. Over the course of more than 35 years of practicing this type of law, I have found that the very best defense attorneys are ones who call me up shortly after your case has been started. And they say, listen, tell me a little bit about what this case involves. And then after that short conversation is over, they will say to me, hey Gerry, what's your demand on this case? Now that answer has a double-edged sword. And the reason why the defense is asking me what it would take to settle this case is not because they are interested in negotiating at this point. It is not because they have authority to offer any money whatsoever. Instead, it is a probe. It is an intelligence-gathering question that can be very useful for the defense later on. Now, why is that? Because the defense wants to know if I have in my own mind an idea of where I think this case should wind up. If I come right out and say, I think this case is worth $20 million, now, the defense may laugh, he may say some derogatory comment and say, how do you know that? Because we don't know the full extent of the damages, of the injuries. And if I give an outrageous number to try and settle this case at the very beginning, now I'm going to lose credibility with the defense attorney and with the defendant's insurance carrier. And that's critically important to understand. Credibility is a huge component of these cases, not just from the attorneys interacting with each other, but also for the insurance carrier who represents the doctors in these cases. If I give them an outrageous demand, they will know that we are not serious about this particular demand. And making an outrageous demand at the very beginning that is not justified based upon the facts of the case can backfire on us. And I don't want to do that. So I will often tell the defense attorney if I am asked, listen, I'm not at the point where I can give you an honest demand at this point. I will do so at the appropriate time. In my opinion, that is a much better strategy than coming right out and giving an outrageous demand that has no significant bearing on the actual facts of this case. So now, when is a good time to start settlement discussions? Is it after your deposition? Is it after I've questioned the doctors? Is it after we put your case on the trial calendar? Is it as we prepare your case for trial? Is it during the course of jury selection? Is it during the course of trial? The answer is yes, 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 and yes. It's yes to all of those questions. Now you might be saying, I don't understand. You're telling me that it's a good time to start settlement discussions at any point during the case? The answer is yes, it is good to go ahead and start settlement discussions. But in most cases, the defense is not going to start negotiating. And in most cases, it is not advantageous to get an early settlement. Why? Because doing that, or at least trying to do that, the defense knows that you might be desperate at that point. They will know that you are trying to get a quick settlement, and they will try and discount the value of your injuries, which means you would only be getting a fraction of the true value of your injuries in any type of early settlement. Now, is that always the case? No, I can't say it's always the case. However, that is what generally will occur if we approach them and say, listen, we'd like to try and resolve this case after your deposition is done, and now they want to know a demand. So if we give them a demand, they're going to discount it, claiming, listen, if we're going to be saving all of this money and time and effort and energy, we expect to get a significant discount on the dollar, whether it's 50 cents on the dollar, whether it's 75% of the dollar. All of that they will take into account, and they will lowball us. And now the case proceeds to trial. Now is the opportune time for them to have that settlement discussion with us. Now, as we prepare getting your case ready for trial, that is the perfect opportunity to enter into settlement discussions, because now each side knows exactly what the facts are. Everybody in this case has testified. We now know exactly what records there are and what records our opinions are basing their conclusions on. Everyone now should have the same set of facts and information, and now each side should have the ability to make an accurate assessment about the risks of going to trial. And based upon that information, now is the perfect opportunity to go ahead and start and enter into settlement discussions. So why do I share this quick information with you? I share it with you to open your eyes, to help you understand how these cases work in the state of New York. You know, I realize you're likely watching this because you wanted to see the beautiful beach here. No. I realize you're likely watching this because you have questions, or likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.